Ladies and gentlemen, it is well known that British start their talks with a joke and Germans with a definition. Since I'm Spanish, I'll start with a quote. It is a quote of the Michigan Supreme Court decision of 1922. The automobile is a swift and powerful vehicle of recent development, which has multiplied by quantity production and taken possession of our highways in battalions, until the slower animal-drawn vehicles, with their easily noted individuality, are rare. Constructed as covered vehicles to standard form in immense quantities, and with capacity for speed, rivaling express trains, they furnish for successful commission of crime a disguising means of silent approach and swift escape, unknown in the history of the world before their advent. The question of their police control and reasonable search on highways or other public places is a serious question. The baffling extent to which they are successfully utilized to facilitate commission of crime of all degrees, from those against morality, chastity, and decency, to robbery, rape, burglary, and murder, is a matter of common knowledge. Upon that problem, a condition, and not a theory, confronts proper administration of our criminal laws. Well, this sounds nowadays like a classic quote about fear of technology. Fact is, though, that in the roaring 20s, the crime rates climbed to a peak when the entrance of automobiles in the market came. The distrustful contemplation of new technologies, theories, or dynamics is part of human nature. Sometimes this fear is an expression of traditionalism and unnecessary precaution. Sometimes this fear proves and turns out to be a good protection for unnecessary risks. A new technology has arisen for a few years ago, and it has been doing the rounds most prominent. Scientists, journalists, policy experts, and policymakers are growing increasingly worried about big data. Now, most of you in this room work with or about big data, so I will not lecture you on the technical definition and characteristics of big data. For the purpose of this talk, I will operate with a very succinct definition, stressing that big data is not a large mass of raw information, but a large heterogeneous mass of raw information. I will also use big data as an abstract, more general term encompassing data mining as well as analytics. I will try to make it a sort of general term just for comprehension and for the sake of shortness. The title of this talk is, Does Big Data Need Ethics? I will try to answer this question by analyzing two main common theses on big data and adding an additional thesis of mine. First thesis: big data is changing the scientific paradigms. The theory of science with regard to both theoretical and empirical sciences must be rethought. Big data shows no causality. Big data shows correlations. It does not need an initial theory or hypothesis to obtain results. Big data stakes out new terrains of objects, methods, of knowing, and definitions or of social life. As David Barry writes, big data provides the establishing amounts of knowledge and information that lack the regulation force of philosophy. Instead of philosophy, which Kant saw as the rational basis for all institutions, computationality might then be understood as an ontotheology, creating a new ontological epoch, as a new historical constellation of intelligibility. Big data offers in most institutions bad archiving functions. It thus lacks historical contextualization. Big data and whole data are not the same. There are many other necessary scientific standards. For instance, we need to know where the data is coming from. The quantity of data collected from minorities living in distant areas will highly differ from the data collected in a rich neighborhood of the city. Remember the problems of the street bum case. If you don't know the case, I will come to that later on. Furthermore, researchers must be able to account for the biases in their interpretation of the data. The correlation of a large amount of heterogeneous data is not self-explanatory. In other words, a list of whats next to each other do not make a why. Manovich writes of three classes of people in the realm of big data: those who create data, those who have the means to collect it, and those who have expertise to analyze it. The last group is the smallest and the most privileged. They are the ones who get to determine the rules about big data and the ones who get to determine who gets to participate. Scholars and policymakers worry about the intransparency of algorithms, which helps hiding discriminatory bias. But discrimination might be an artifact of the data mining process itself. Data mining learns by example. What a model learns depends on the examples to which it has been exposed. And finally, the specific methodologies for interpreting the data are subject of intense philosophical debate. Can the data represent an objective truth? Or is any interpretation necessarily biased by some subjective filter or the way the data is cleaned? Ladies and gentlemen, the procedure of elaborating a theory based on evidence and not the other way around is called inductive reasoning, and it was developed a few thousand years ago by Aristotle. The critics of this scientific approach raised their voices already in the ancient world, starting with Sextus Empiricus, alluding to many of the bias mentioned before, over philosophers in the time of the Enlightenment, like David Hume and many others more. The theory of science has been handling exactly with those issues for centuries. The quantity of data does not affect the abstract rules and principles of the theory of science. Smaller amounts of data are subject to the same scientific rules than big amounts of data are. Size doesn't matter. From the perspective of the theory of science, no, big data does not demand a rethinking of the present standards. It only demands better implementation. Second thesis, big data is raising new ethical questions. Lerman and many others have often raised worries. The non-random, systematic omission of people who live on big data's margins, whether due to poverty, geography, or lifestyle, and whose lives are less datafied than the general populations, For instance, the street bump case that I was talking about before from the city of Boston is a smartphones. It's an app. It's from the city of Boston. Was released by them, and it uses smartphone sensors to identify whenever a car is bumping. And it then sends that information to the city roads maintenance team. But the system has a conceptual, or it hasn't anymore, it had a conceptual bias. Since richer and younger people were more inclined to have a smartphone, and still are, and download the app, bad roads in geographically and digitally remote places would not get fixed because there wouldn't be any reports. When the designers realized about the unfairness of its algorithmical outset, they decided to correct it by giving more weight to bumps from less wealthy areas. Now, datafication, my favor in this example, the users. But there are voices in academia concerned with the dehumanizing consequences of a datafication of society, like, for instance, cookier. Big data, my subtle and unnoticed, perpetuates social inequality, stealing the freedom of privacy rights of human beings away. And furthermore, it can change gradually the core essence of humankind. Quoting Morel, rather than deciding for yourself, who am I and what do I want, the right to identity, big data creates the risk turning this into being told who you are and what you want. Morel assumes that this will lead to renewed ethical considerations of the right to identity. Should individuals be given a chance to trump the probabilities, or should we all be ruled by data, turning our society into a data dictatorship? What kinds of ethics do we need to safeguard civil rights in a world of big data? Should there be a law protecting from discrimination based on new criteria, such as lifestyle? Big data will certainly uncover most social inequality. It might help depicting more patterns of inequality under the most unexpected circumstances, social, political, and economical contexts. Here, as in the datafication argument, big data might be both a valuable or a hurtful instrument for human beings. Indeed, it might homogenize individual into social categories, or quite the contrary. According to the long-tail theory, big data will adapt to the most individual preferences, allowing for more social and cultural diversity, thus generating more niche, no homogenization. Ladies and gentlemen, big data is not a moral agent. It is an instrument. And hence, neither the data nor the algorithms can be held for morally responsible. Data, information per se, withdraws from concepts such as good, bad, and moral. The ambiguity depicted in the examples given before, in both examples, it's the logical consequence. Hence, ethical criteria and evaluation can only apply to the actions of data miners, researchers, analysts, and decision makers regulating the algorithm, either legally or mathematically. Apart from their imperative obligation to respect the human dignity and freedom of any other individual, they have to ponder, for instance, on the legitimacy of justifying their actions as ethical simply because the data is accessible. They are thus accountable to the field of research and also to the research subjects. Equality as fairness, freedom of choice, freedom from discrimination, dignity, privacy. These ethical principles are the values data miners, analysts, and researchers have to respect and are morally responsible for. The potential risks of big data concern no new human right or ethical principle. The quantity of data does not affect the abstract rules and principles of ethics. Smaller amounts of data are subject to the same ethical rules than big amounts of data, size doesn't matter. From the ethical perspective, no, big data does not demand a rethinking of the present human rights. It only demands better implementation. Third and last thesis, my own. Big data only visualizes a deep-seated problem in societal change. Recapitulating the 2 points above, big data requires no new scientific or ethical demands. The problems with big data are not new and have its own origin outside big data. Moreover, those fears mischaracterize the very nature of humans. There is a free will in the nature of man. Humans use reasons or beliefs to undertake a decision. The reason and beliefs might be rational, emotional, spiritual. Human civilization has been collecting and producing knowledge, that is data, for thousands of years. This knowledge serves civilizations for better understanding and decision-making. If the human being wasn't data-driven before, and considering the arguments given before, why now? Stating big data makes of man data-driven automats implies negating free will is part of the human nature. If humans are so easily enticed to data-drivenness, what other structure or social paradigm should humans adopt instead? Ladies and gentlemen, the origins of these fears lie somewhere else. They are fundamental ones. The digitalization has changed our concept of time and space. There is a difference between being in public and being public. What is the status of public data? And can't it simply be used without permission? What does it mean for someone to be spotlighted or to be analyzed without knowing it? What does it mean for someone being at home and being analyzed? What is the private space and what is the intimate space? Is there a private space in public? Furthermore, innovation within the digital field was developed within well-defined and delimited sectors, such as academia, the military, and yes, the porn industry. Experimentation was carried out in niches, and in the market came a predominantly well-developed product that had undergone in the experimentation phase in very close areas, as the ones mentioned before. Today, innovation is being carried out not only by academia and the military, but mainly by the economic mainstream, amidst the majority of users. This seems to aggravate the already described uncertainty and insecurity of society, particularly with regards to privacy rights. So those are the fears that I was trying to explain that we perhaps might follow in the conversation afterwards. To conclude, the decision of the Michigan Supreme Court in 1922 on cars was based on statistics. The reason for crime was not the existence of cars. The reason for the crime statistics was social inequality and political unrest. The fact that only few people in society owned a car at that time. At the beginnings of the 20s, not even the police had a car, not even the police in Michigan. That was not a reason, but a window of opportunity. Once the economic and social cleavages decreased, and sure, more people could afford cars, the crime statistics did too decrease. Big data has the potential to perpetuate inequality because of information asymmetries. Big data has also the potential to detect and show inequality. It is the sellers and monopolies of knowledge what divides society in weak and powerful. It is bad regulation, the inefficient implementation of human rights, what might threaten the well-being of society. Fearing knowledge is refusing the very nature of humankind. It means refusing, to say it with Kant, to the emergence from one's self-imposed immaturity and to a possibility of freedom. Thank you very much.
Thank you, Lorena, for this insight. You touched upon a number of very important topics. You lined out the difficulties in correlation and the relationship to causality and old traditions of scientific work. You also pointed to the fact that there is often unknown bias in data, and you hinted us towards the rule of probability. You also made very clear that, and that was your closing, I believe, that the exclusion or the information monopoly is one of the core aspects that we need to consider when we're talking about ethics and regulatory frameworks. But before we jump into all these topics, let me first introduce the panel. Further to the right is Jana Moser, and I've met Jana Moser a couple of years ago in another collaboratory, and working exactly on that topic, private and public. And she's since then moved away from StudiVZ, where she worked back then, and is now with Springer, and is a privacy expert there. Just came back 2 weeks ago from a 2-month research stay in the US, looking into privacy technologies, ending up more looking into Bitcoin technologies because she couldn't find too many privacy technologies out there, if I got her right. And I'm very happy to have you here on the panel. And maybe no further introduction is needed for Ms. Kotthaus, who has already been here this morning, but to round up the complexity of this group, she adds a number of topics because she's been also working for the European Lawyers Association and been founding president in 2001, I believe, and besides having studied the law, she also has a degree in Islamic study. So I think we have a nice setup here of legal philosophy, Islamic study backgrounds, and the other aspect we're well balanced in is we have academia on the stage, we have industry on the stage, and we have regulators, if I may say so, and policymakers on the stage, which is nice. There is a certain lack, and I'll address that later on in the setup of the panel, but I'll come back to that later. But now, jumping into the topic and the core of the topic, I would like to start to Ms. Kotthaus, raising the question that that Lorena has just mentioned. At its core, the question of how do we actually approach the field of exclusive knowledge derived from big data that is in the hands of very few. Do we have any instruments to tackle that, or has there been in the Commission been any discussion on how to deal with that?
Yeah, I mean, if you talk about our proposal for the framework regulation on data protection, we don't address big data as such. Yeah? We tried to have a technology-neutral terminology because we wanted, you will not find the word cloud or something like this, big data. It's not mentioned there because we tried to find a language which is, and that's why also it's a framework regulation. Our idea was to set up some principles because we think as all this, let's say, digital world is developing so fast, it doesn't make sense to make too detailed rules. And so what we have to agree on is to have certain clear principles and then leave room for example, regulation by the industry, regulation by regulators, data protection officers, and so on. Then only later coming in, like the Commission or others, and policymakers, and even then legislators. So that was our principle, and there we have the basic fundamental right, which is on data protection, enshrined in the Charter for Fundamental Rights, and therefore we think all the ethics we might have, whatever, yeah, we agreed already on a written law, which enshrines the ethics. What do we understand as needed in this context of protection of fundamental rights? And what do you need also to enforce it? That you have to have independent control of it, that you, and etc. And so we think this is a flexible approach where you can at least hopefully live with for 10, 20 years, and we don't have to renegotiate all the time what our basic rules are.
Well, let's hope for the best. Jana, yeah. would you agree that the regulatory framework we're currently developing on the European level, and you've been a privacy lawyer and expert for a number of years now, is sufficient to help us out for the next 10, 20 even years given the fact that a lot of the big data isn't even tackled by the regulation. The regulatory framework usually is applied when there's personal data, which is defined as identifiable information and can be related to an individual. And in big data, we usually have aggregated data that doesn't speak about individuals, but groups of individuals. So would you agree that that is sufficient if we just regulate these small instances where we have really personal data?
Honestly, I can't look into the future, and I have no idea what will come, especially out of the United States tomorrow. So there are so many innovations I can see right now, but I have no idea what will really come in the future. So honestly, I'm not quite sure if it will be sufficient in the next 5 years. So I don't trust, that's nothing to do with you or the Commission, but from a company's point of view, I would say I'm more convinced that we will need a change of the regulation maybe after 3 years, even if it is applicable, the regulation in the future. We have a kind of period now when it will be effective, and until then we have something else, not cloud computing, not big data, but something else. And I'm pretty convinced that there will be something which is not covered by this law and by the regulation. So it's very difficult to think about regulation in the future for several years with this speed of technology we currently see in the world.
That's one of the difficult tasks of policymakers, please.
Yeah, as a concerning this, that it might not be covered. I mean, what we are concerned of is our personal data. As soon as they are not personal anymore, we think, why should not businesses use it? Huh? As long as we are not concerned as an individual, fundamental rights are not at stake. We don't want to regulate more than we have to. You know, otherwise you talk always about over-regulation by Brussels. Yeah, this is not what we intend to do, and that is also. I mean, we have, for example, here in Germany, we have our constitution with fundamental rights that dates back from 249. We have lived with these fundamental rights very well until today. We could even solve problems as in the, informational self-determination with this constitution by the courts, okay, but at least the rules were flexible enough. So I think the solution can't be to set up always new rules. We have to set up a framework where we can say, this is the essential things we want to, that are the boundaries, that are where we have to adhere to and we have to respect. And then let's see what comes up, yeah. But that's what I just wanted to add.
Yeah, generally I totally agree with you, especially when it comes to the subject of the regulation. But at least we see that in Germany that a lot of, especially data protection authorities, really extend the applicability of the regulation or the applicable law. And then we talk on the one hand about information that might be personally identifiable in the future. Because every process which is set up to prepare some kind of personally identifiable information in the future, and we have no idea what will be there in the future. Big data, what is now aggregated and anonymous, might be in 2 years personally identifiable. So it's very, very difficult, I think, from our current standpoint. Is this subject here, this data and this information, really subject of this regulation, yes or no? And that's the reason why I think we talk about privacy and data protection, but we should focus more maybe on the rights behind that. So do we really want to protect, for example, the freedom of speech, which is tightly connected to privacy? Because if I don't try to inform myself in the public because I know someone collects data about me, even if it's aggregated, I don't know, maybe I will change my behavior. And I think that's the core thing. It's not if it's person identifiable or not, if it's privacy, really the core privacy, the question of do I have this kind of privacy in the future, do I have a public privacy? But it's more about my human rights I have, and you mentioned, and we should focus on these human rights we have, and these human rights shouldn't be limited in whatever data processing we have.
Yeah, I completely agree, but you have different fundamental rights which are here at stake, and that's a normal situation. We have that since hundreds of years, that we have on the one hand the right to privacy, the other hand the right for freedom of expression. That's an old problem. It's centuries old. As long as we live and exchange with each other, we have this problem. And courts ever since have ultimately solved these cases. And I mean, there is no other way than having principles and then apply them to the concrete and individual case. So, for example, if you have now personalized or personalizable big data at a certain point in time, which give a lot of interesting information for people who want to inform themselves what's going on, then nevertheless there might be an individual who says, well, that goes too far for me. And then it has to be balanced, this right of the individual against the information rights of the others, and then you have to see where you struck the balance. But you can't say that in advance. You can't regulate this. Yeah, you have to, in the end, that's a question of implementation of the law, but not of regulation. I think we have to...
Well, we have to regulate probably, and we can probably agree that we have to regulate in those cases where we foresee problems coming up that need to be solved on that regulatory level. And my question in the center, and I want to take that over to Lorena, was that the way we're addressing this problem by looking at informational self-determination and looking at personal data as an anchor for, let's say, interference by regulatory frameworks. Is that the right angle? Because in big data, we often even don't have those personal data situations. They're not personal data, so the regulatory environment is not applicable. But at the same time, we're looking into information monopolies, exclusive availabilities of information about human behavior in the hands of very few. Traditionally, this information was in the hands of academia, and academia has this golden principle that they work on publishing. But now this information is more and more in the hand of, dare I say, even clandestine organizations. And ultimately, to break it down on maybe a too primitive kind of way, but who is the owner of the data? Is it the user? And I don't mean the individual data, but the information that is gained from analyzing that data. Is it the user or the data subject? Is it the company that gathers the data, the expert who you mentioned in your talk, or is it society? What do you think, Lorena?
Well, I don't think that we should continue with this rather archaic semantic approach of conceiving privacy with the concept of data. Personal data.
I was not talking about privacy. Let me be very clear here. I was talking about the knowledge gathered from big data.
Okay, so
who is the owner of this knowledge? Who has the right, or who is entitled ethically to use that data?
I wanted to go to that. What I wanted to say is the way you ask your question, it implies that there is a data ownership. And it implies that within this ownership of data, that there is some interest or claim to privacy, and on the other side, perhaps information freedom and research freedom, and so on. And the point that I have, if you want to address this in terms of privacy, of saying, I don't know exactly where you want to go with this question, but if you want to address this question in terms of the person that owns the data is the person that owns the privacy, that owns the knowledge and owns the power, then I would say, well, I think privacy is much more than data. I think power is much more than owning personal data. I think that the concept of personal data is very misleading, and I think that if we work with big data, the least thing that we should operate with is with ethical categories like data, personal data, because personal data is nothing. It's a neutral thing.
That's what I just said. I wanted to raise the question whether we really need to talk about personal data, but we need to talk about the knowledge derived from big data. And whether that is something that should be governed by rules, by ethical rules, whether we need to develop as a society an understanding how this data is to be used. Is this to be used by single organizations, or is it to be used for the general good of society? And thus, must it be made available, even if it was collected by single entities, right? And that has nothing to do with privacy. It doesn't even need to be personal.
Okay,
data,
then I would
right?
say I would go the other way. I've been thinking about this a long time. And monopolies of wisdom, of knowledge, are both a problem and also a problem for economic innovation, but also for research innovation and all this stuff. On the one side, from the perspective of the academia, what you have in terms of these wisdom monopolies or knowledge monopolies is that you have the researchers from the inside and the researchers from the outside. So you have the researchers working perhaps at Facebook that have access to different data, to the data that a person at the University of Munich might have if they want to contact Facebook and say, well, I would like to have this data and this, you're not going to get everything. So this is, on the first part, one thing that concerns me. On the other side, of course, if bigger companies keep those data and can make their, and develop their own business based on this data, this, on the long term, it's a sort of problem for companies, for small and middle companies. So what I've been thinking a lot with other colleagues was, and we are not jurists, we're legal philosophers, we think it differently, we have a different approach. But we've been thinking about the patent concepts that, for instance, we have with medicine. So a company just creates a drug for, and they have this patent for perhaps 8 years. And afterwards, they just have to release it free, and everyone can use that. And we've been thinking about concepts like that with regards to data, saying, okay, perhaps a company that has this data for a couple of years then should just release this data free and give it also open as a data bank for other companies. I think that would be perhaps...
So the regulatory approach would be you have like a window of opportunity where you have a monopoly on that data for a couple of years, and then you open it for the public good. Would that be an interesting approach?
I think it's a very interesting approach. And for the rest, I would say dealing with monopolies, that's not really typical data protection.
We're not talking about data protection, we're talking about ethics
that's
and
what
big
I
data.
just said. I'm sorry. When we talk about monopolies, that is not not so specifically data protection law, that's competition law. Huh? So how to deal with monopolies, and how do you see that you have a fair market-based economy, and we have a system where we say we accept certain concentration in a certain field until a certain degree, and then we start examining it and see whether this is market distortion or not. And we could also, I mean, you might have seen that the Commission has just published yesterday a decision on that's on tax-based, but nevertheless against Google in Ireland. And so that's also a question of how much influence does somebody have in a certain area. Yeah. And we are examining this. So I think indeed patents are a way of, having a certain right for a certain time. You have invested in a certain technology, you are allowed to use it for a while, and then you have to release it free. I think that's an interesting approach. And yeah, we should not forget that also in this context we have the normal means against monopolies. Yeah.
Now, allow me to take this a little bit further and address the elephant in the room. There's obviously a biggest data collector and the biggest aggregator of big data that we've been learning about more and more during the last 12 to 16 months, and that's the National Security Agency, right? On this occasion, I'd like to introduce the fourth virtual panelist, who is Anne Roth, who couldn't come today because she joined with the German Parliament to look into what happened at the NSA and to look into the NSA Untersuchungsausschuss. But to represent civil society on this panel, I'm trying to kind of put a statement on, hopefully in her sense, into this panel. What the question really is, to Lorena first, what do we need to do to deal with that? That's a data monopoly there. Patents won't help you. How do we address that?
With no regards to big data, so we are excluding big data because the funny thing with big data...
Just considering the fact that the NSA could be using the big data for manipulation, and I'm not talking about manipulation of individuals only, but manipulation of societies, right? There is a difference between just addressing one individual person and trying to change the results of an election by giving the right advice to the right person and so forth.
Well, with regards to technology, of course, the funny thing with big data is that if you have big data, you don't need blanket data retention anymore, which is a very curious, ironic thing. But with regards to what it is to be done, I think that most people within the civil society have been erratically trying to knock at different doors. And in my opinion, what we must understand is that the NSA, or national security agencies, they don't deal with privacy, they deal with national security and with national intelligence. So those issues are excluded from privacy issues, from data protection issues. They are excluded in all international contracts that we have. And if we really want to address this in a proper way, considering that there is no sense to make a bilateral no-spy agreement with anyone, because we have many different ways to circumvent this, I think that the only way is to go the complicated way, which would be an international agreement. We used to have a very long-lasting agreement on the Geneva Convention on weapons and on war, and we've been having some updates within those contracts, and it was an international contract, and it doesn't work very well, but it somehow created a standard, and of course we also have different instances to address this. On the other side, this also would mean that this sort of agreement should be handled with many, many other countries in the world that do have very different concepts of privacy. But I think, in my opinion, that this is the only way to go.
Before I go and go back to Jana for the responsibilities that industry could have in this area, what can we do in the meantime before we have an international agreement and no spy agreement, which is not really at the horizon right now, even if you look quite far. So what would be the leverages of the Commission to protect the human rights, but also the democracy within the European Union against foreign agencies?
As you rightly point out, also the European Commission, neither the European Union has any competence in national intelligence. But I think I referred to this already this morning, that the hook we have is that we, the EU, is responsible for protecting the data of our citizens and businesses versus third countries. And so what we can, let's say, rule or negotiate on is to protect these data. And what the NSA does is that they use the data of the companies and force them, for example, to deliver them certain kind of data, as we had in this Irish court case, for example. And we can say, well, there's a conflicting, it's now conflicting even judgments, because the European Court of Justice says European law is applicable and not the US-American one. So companies have a certain problem there, what to apply. That is indeed a bit quite unfortunate, but I think there will be a solution sooner or later for this. So that means we have we have a hook to tackle this, and that can be, it's not directly effective, but it can be quite effective in the indirect way. Yeah. And you know that we negotiate or we discuss the safe harbor agreements. We have in last November we had a communication where we said there are 13 points which have to be tackled because safe harbor doesn't work as it should. And for most of the topics we have found a solution now, but there are still some open points. And one is the national security clause, and the other one is also the access to justice for Europeans when they want to go in to defend their rights in the US. And there is no reciprocity. Sound to me like
they are rather crucial points.
Yes, indeed.
Right?
That means it's not clear whether and when we will. Pardon?
If there is no agreement with the US that safe harbors, say, would include limitations and legal ramifications for access by their services, what would be the
safe harbor is a European instrument. Yeah, we can apply it or we can't. It's not an agreement with the US.
Absolutely.
So, and you might have heard that, if, for example, from the European Parliament, there are voices who say, "Why just we don't cancel it altogether?"
Yeah. The adequacy
and that's a
is not
political
there
decision which has to be taken by the next Commission, and we have to see. We still negotiate, but we have to see where it leads. Huh? The state of play for the moment is that we still try to find a solution. They meet on a regular basis to tackle these issues, but it's then a political decision indeed for the next Commission when they see how the negotiations go on or don't go on, or what to do with it.
Would you estimate that there would be the political power to actually take away this adequacy decision that is underlying safe harbor? Would the Commission really say, okay, we don't accept companies subscribing to safe harbor at the Federal Trade Commission. We don't accept these companies to handle the data of European citizens anymore?
It's always that you have to tackle and to balance certain interests. We had that with passenger name record data. We have with these sensitive data, we have the same problem. And it's a political decision which has to be taken in the end. Huh? It's not me, it's the political part of the Commission, but certainly they have to see and then also to decide and then sell it to the public, whatever they decided upon. Yeah, it's not easy.
I must say that is a very difficult position
and
to be in. Yes.
We will see what comes up. I can't really tell you what it's coming up, but the discussion is ongoing, and it will not be an easy decision. And it might well happen that they say to a certain point, as if we don't come to an agreement, we have to do it otherwise. You remember with the PNR agreement, Parliament said no at a certain point in time, and then it had to be renegotiated. It's a process, and we have to see where the process leads. But I can only invite everybody who is interested in these topics to voice and see their concerns, and to see and influence the process and see what's the outcome. Yeah.
Right, Jana. There's regulatory approaches, of course, but there's also responsibility by companies themselves. On international level, the RADI principles have been established a couple of years ago, and they are now transposed into national action plans, voicing the responsibility of companies for human rights. And the UN General Assembly just recently reiterated and strengthened their understanding that privacy is one of the relevant human rights, including, and that was significant, the protection of democracy enshrined in this concept. So what is the obligation or the responsibilities of companies, especially in the context of allowing access to large organizations of foreign countries to such data?
I think you have to distinguish between the size of the company, what's possible for a company. For a larger company or an enterprise like Axel Springer, it might be possible for something like self-regulation. For smaller companies like startups or SMBs, it's not possible, of course, to go beyond the law, so to really restrict yourself more than the law really already does. Of course, everyone should comply with the applicable law, no question at all. But I think when it comes to the access of data, especially from foreign authorities, there is the applicable law on the one hand. On the other hand, what's always possible is what you don't have, you can't give. So just limit the amount of data you have, but that might contradict with the need of big data, of course. But if you aggregate the data and you try to anonymize the data, of course, it's not interesting at all anymore. But another problem, even as a big company, you can't avoid is that the authorities, especially in other countries and in Germany as well, they collect data by themselves. So they don't really need the big companies or the smaller companies or whatever company you think about. They do it by themselves. And they have the possibilities. They have the people, they have the storage possibilities. So these are two aspects, I think. We can't really avoid an intentional maybe infringement of our environments so that they can really hack us, for example. We can't avoid that. No one can. And what we can do is we can stick by the law. We can comply with every regulation we have. We can believe in self-regulation. And it depends on the size of the company. If you really believe in privacy, even smaller companies can do that. You can just say we have additional requirements, how we deal with the data, are we more transparent, what do we really need when talking to authorities, all the things you can do, of course, when you are a company. But I think it's more the idea behind the company. If it's just a business, and a company is a business with employees who wants to have their salary, so you have to get money. You just can't believe in privacy, maybe like I do as a person. Just can say, privacy is very important for me. I believe in it, and everything's beyond that. That doesn't work for a company. But otherwise, we wouldn't have a great economy in Europe, and especially in Germany.
One further aspect is also, I mean, if a company gets requests by NSA or any other public authority, you can always refer to mutual legal assistance agreements. Yeah, you can say, well, there are official channels to get it. Go to our public authority, and don't go to us directly. And that's what we also try to convince in our negotiations with third countries. We say, we have these agreements, use them, and leave the companies, and we deal with this, and we have our means to tackle this problem in the right way, and so that companies are not directly then targeted by such requests.
Mm-hmm. Now, trying to pick a little bit again on the what you just said is you anonymize and then it's not interesting anymore, because I think it's really important to get this understanding that the information asymmetries that Lorena just pointed out in the beginning, I believe, are also there with anonymized data. Or did I get you wrong with your introduction?
No, that's right.
Right? So even if the data is anonymized, if it's collected by the NSA, it may still be of high worth.
Of course, what we should understand first is that there is no technical possible 100% anonymization. All data is personal, and you can trace it back to a particular individual, especially with big data. So there is no way of creating anonymization in terms of creating a concept of anonymization based on technicalities. However, I think that we can create a concept of anonymization and pseudonymization as a process. As if we do in science, if we do have to work with personal, at least the gathering is sometimes, not always, but sometimes it's personal data, and you can see who, what, under which circumstances. And there is a person that is in charge of anonymizing that data. And there are very few people that are able to access that part. So if we would think of anonymization in regulation terms, would be conceived more as a process and not as a concept of let's do this technically, because let's do this technically is not going to work. I think that there is good possibility of at least creating a process where there is a high degree of pseudonymity or anonymity, and where there is a certain possibility of accountability towards the person that then makes possible a re-identification. Mm-hmm. So yes, there are many things still where I'm not that sure. I think the data protection regulation draft does not consider this, which is
it's considered in the negotiations now, huh?
I hope so.
Yeah.
At least the draft doesn't look like that.
Yeah, but the Parliament has especially also hinted that in its opinion, and they it's at least anonymization, and is a question which has been raised in the negotiations, and I think everybody has understood that this is really an issue, and they have to tackle it. I think at least that is one of the points which always appear also in the let's say in the negotiation papers, that is one of the open issues.
But before we go back to more of the core topic of regulatory approaches, let me stick with the manipulation topic for one more question, and then we'll come back to that. And that is, and it's already been raised, the intricacies of freedom of expression and other fundamental rights may play here a different role. And the question is, could it here be similar to what Jana said earlier, that the potential of manipulation that is in such data, the information asymmetries, as you pointed out, also not only have an effect of privacy, again extending the question beyond these fundamental rights that we usually look at, privacy. No, does it have an effect on the freedom of expression as well, in such a way that we understand the freedom of expression as a right to seek, receive, and impart opinions and other expressions, right? And on the receiving end, you addressed the seeking end, but on the receiving end, this must also be part of the freedom of expression, that we can be sure that the reception is free of manipulation. Would you consider that part of such a right, or is that stressing our concepts of freedom of expression too far?
No, it doesn't go too far. If you consider the Article 10 of the European Fundamental Rights Charter, this is precisely what Article 10 says. No one should monitor communication. So, thank you very much. This sort of cuts both ways, because on the one side, regulating communication or monitoring communication, at the very end, it leads to chilling effect, especially for minority opinions. Those are minorities, people that have some sort of dissident opinion, are always going to experience chilling effects when they have the impression that communication is being monitored. But they are also going to experience chilling effects when not also communication is being monitored, but also regulated. So I think that what Jana was pointing out before should be also considered. We have right now two very difficult sides with regards to freedom of expression. On the one side, we have the whole NSA affair, and this sphere of mass surveillance on the one side. On the other side, we have data protection, which is regulated a lot of stuff that also is being regulated from the other side by freedom of speech regulation. And at the European level, what I can say when I work with other scientists and also activists is that we are really concerned because we have at European level a sort of homogenization, or kind of they are trying homogenization with regards to data protection, but we have with regards to freedom of expression a very heterogeneous landscape, because that's something that is up to the member states. So what the European Union is trying to do is from the one side to regulate communication with regards to privacy, but also with regards to freedom of expression, whether it's being addressed explicitly or not, but this is what they are doing. And on the other side, the freedom of expression regulation is being also led to countries like, for instance, Hungary.
I totally agree that that is a very interesting topic, but that will open a whole can of worms for this panel now if we go into the Google case.
I just wanted to address this. Both points are important, not also mass surveillance.
Absolutely, but I'd say it's beyond scope. But going back into the topic of big data and coming back to Jana first. I read an article in the New York Times a couple of weeks ago, and the title probably says it all. The New York Times titles, "Google is target of European backlash on US tech dominance." Right? And quoted in this article is your boss, Mr. Döpfner, and he is quoted with his well-known open letter to Eric Schmidt and calls for new approaches to regulate. And so the question is current regulatory situations and with such a dominance of US players, especially in that market that we're discussing today, is this addressed well enough with current approaches, or where do you see deficiencies? I'm pretty sure that you won't say, no, we have to regulate Google off the market. That would be too simplistic. But what are the proposals?
Yeah, my general proposal, I think not only regarding Google, but regarding everything when it comes to monopolies and creating monopolies, is that we have to see the big picture. And that's very important. A lot of people and professionals who talk about data or privacy or free speech or other topics, they see just their single subject of the talk and of the speech, but they miss the whole picture. Let's maybe go a bit away from Google, although Google is doing it as well with Google Ad. We have now Facebook with their Atlas. We have Amazon with their ID. We have Microsoft with their ID. And yeah, that was it. So we have some big companies with their IDs. They collect data, a lot of big data. And now, let's come back to the problem of monopolies. Is the problem of monopoly or creating monopolies really addressed and really solved by the regulation? I would say no, at least not under the current draft, what I've seen. The point is, the more we ask for example, or especially an explicit consent, the more we do for the monopolies. Because the monopolies already have their databases, they already have their registered users, and for them it's very, very easy to set up their databases and to collect more data regarding one person under one ID. And they try, of course, from an economical point of view, and as a company, I totally understand the approach to say, I have my idea, I want to reign in my environment, and my environment is my operating system. And we only have Android, Windows, and Apple. And that's, of course, Linux and all the stuff, but most of the people use these three environments. And everything in this environment is regulated by this provider. And I think this topic is when we only talk about privacy and we don't want to collect data, for example, via cookies. That's one topic, that's one privacy topic that might be not okay to have flash cookies, to use flash cookies, because you can't delete them. That's one topic we can talk about, I think, in length overnight with data protection authorities, and you might know that very good, and IP addresses and all the things, but that's for the big pictures. The big companies are laughing about that, but that's not the subject of the discussions of the big companies. They have their IDs, they try to set up and to strengthen their monopolies, their power they have. And I think this topic, that we have to see the whole picture, the whole society, and what we're doing now when we regulate more and more and really playing in their hands. I think this subject and this topic is not really covered by the current regulation.
But I'm sure you would want to jump in. I was sure you would. Let me rephrase the question before you do.
Oh, what a pity.
Now, let me look back 1.5 years, and high-ranked member of the diplomatic corps of the United States Embassy in Berlin was then quoted, and I suspect that it's right, well quoted by the Süddeutsche Zeitung back then, that the regulatory approaches with the privacy regulation in Europe is effectively opening a trade war towards the US. And I found that very harsh words in this context. But on the other hand, is that maybe something to consider? That, I mean, why not be protective of our industries and allow them maybe also to evolve different models and approaches towards innovation than the US-centric model with the Californian-style entrepreneurship model, which is nothing to say against the entrepreneurship model, but maybe something about the specificalities of business secret protection. We could go a different route and say, when you're collecting personal data, when you're looking for big data, you have to open up your business secrets after a couple of years, or you initially have to open up your algorithms, like some politicians start voicing that in the public. So is there room for such approaches, or are we just currently even closing the last remainders of such individual approaches by signing an investment protection agreement?
Oh, so this is covering now several topics. So, first of all, when trade war again, Europe, US, I think, okay, that were harsh words, but I mean, they defend their interest, we defend ours. Yeah? To a certain extent, we shouldn't get too excited about it. We have our interests, and we intend to defend them. They do the same. We come from completely different concepts of privacy. They say, in general, you can do whatever you want, except it's forbidden. We say the other way around. So there are two concepts, but slowly but surely, I think we can see a certain development that it's a kind of moving closer together. Yeah? Otherwise, you see how the big US companies are suddenly taking care of clients' worries about data protection. They have never done this before. So I think let's say a bit, at least there is some light at the end of the tunnel, I would say. Then when talking about the big picture, indeed, we should not forget, as I mentioned it before, tax law. Very efficient. Very efficient. Don't forget, Al Capone finally was caught by tax authorities. Yeah. So we should really see what instruments we have at stake, and it's not only the classical instruments. You get them sometimes also looking a little bit around the corner. And then concerning TTIP, as has been, I think, underlined several times by Vice President Reding and others, that data protection is a fundamental right, and it's not part of any negotiations on TTIP. And that opens really another box. But I mean, there we can be really crystal clear. That's not in the mandate, and we will not negotiate in TTIP and in these negotiations on data protection issues.
Now, with that, we're nearly through the session. At least we should give the audience some room, I believe. So I'm to quote Stefan Noelle earlier, I need your help. Is there interest and And questions or even statements from the audience regarding the topics that we've been addressing so far. They're over there.
Thank you. Yeah, Stefan again. This idea of regulating access to data that companies are collecting in the regulatory framework. As far as I know, there is this Article 42 which tried to tackle that in a way which has been removed. Or I mean, can you elaborate a little bit on this? I mean, the concrete status of this provision in the current framework. How likely is it that at the end we will have something like that in the new data protection regulation or not? Or is it?
So you're talking about Article 42 in the regulation that addresses the sending of data across the Atlantic, essentially, or
exactly.
towards countries beyond the European Union.
Interesting number, by the way, for this article, but that's just a side comment.
Yes. So I think that goes to...
Yeah, I mean, the only thing I can say is that the Commission, for the time being, has no problem with this Article 42. And it's, I think, I'm not exactly in the picture. I think the Parliament has introduced that again into the text, if I'm not mistaken. And now let's see what the Council is doing with it. I mean, they are negotiating it. We have the next minister meeting for Justice and Home Affairs, 9th and 10th of October. Data protection will be on the agenda as far as I'm informed. So let's see. I mean, we all agree, meanwhile, that we want to have an agreement in 2015. So I think the pressure is high. The expectations are also high, so I hope that they can take this as a basis. But more I can't really tell you at the moment, because we have just to wait how the Council positions itself.
Is there any other?
I have one thought. As a journalist, I witnessed a great piece of law which was kind of data protection, which was the Sarbanes-Oxley Act in 2002, which actually the Sarbanes-Oxley Act. Before that, actually, American companies had no problem of publishing their revenue data from markets like Germany, and after that, there was no data available anymore for most of the companies. Not that it's not allowed, but the CEO is just personally reliable, can be made liable for wrong figures. So I was thinking, we're talking a lot about data protection, and we talk a lot about data processing rules, but I'm missing actually rules on what happens if somebody is abusing data, what happens if somebody is doing something wrong with data. So there's not really a rule to it. And when I look at the Sarbanes-Oxley Act, I mean, that from one day to the other changed markets. And that was a pretty clear rule. So would that be an approach to make actually people, CEOs, liable for abusing data within their company?
We could also address that not only to Elisabeth, not to put her in the focus all the time, but also to Jana. Is there a lack of pressure for companies to abide the law and to be compliant, if I understood you correctly? Is the mechanisms too little?
I'm looking at the current law we have in Germany. I would say regarding what could really happen with the data, and especially with a person, if you misuse the data or infringe someone's right, I would agree with you that the fines are too low, because it's, I don't know, I can't really remember, but it's, I think the highest fine is 250,000. You know it better, 250,000. For one case. Of course, then you can accumulate it, and there was this legal case with the surveillance via cameras, and then we got from the German Deutsche Bahn, we had, I think, 1.5 million or the like. So that's possible, of course, but honestly, does it really hurt a big company? I'm not quite sure, and so I agree with you. So to really protect the person and to really make it a really good law, we need, of course, something on the other side. We need some punishment that doesn't, otherwise it won't work. I mean, but on the other hand, what helps is not only punishment, but also you need to get some benefits, especially to set up something like privacy by design, by default, anonymization, pseudonymization, and all the things. If you don't connect these means with benefits, the companies won't do that, and they won't install privacy by design or by default or more the things and data minimization if they don't get something out of it. So it's not only about punishment, but the other way around, I think. So we have to combine these two means to have really an effective privacy.
Yeah, I mean, if you take, for example, we have also not only this act you are citing, we have, for example, a very effective competition law in Europe with high sanctions. And what we have proposed in the regulation is a sanction. I think we went originally in our proposal was 3% of the global turnover. Mm-hmm. Parliament has proposed now 5%. Let's see where we end up to. But at least we can say for competition law that has proven to be efficient. It hurts even the big ones. So I mean, I think there are possibilities in the new law. We agree that for the time being we have not enough instruments, but if that would be finally adopted, that would be, I think, a helpful instrument.
So there comes the time when privacy legislation has equal leverage than competition law.
That's our aim.
Excellent. Now, there's one more last question. Very quick one. Oh no, that was just the sign that I should go for the final round, which was was just intended. Thank you. And we'll go for a final round of questions. And for this closing round, I had the idea that each of us needs to switch sides and put each other in other shoes. And so, Lorena, if you were a commissioner in the area that we've been currently discussing, what would be the single most important things you would change? 2 or 3 sentences only.
Okay, I will throw away the whole data protection regulation draft and try to do something new, really new, based in human rights principles.
Excellent. Elisabeth. So say, we understood that in discussing the new directive for data protection, there was some activities from different players involved, and there were industry and civil society actors approaching commissioners and, of course, the parliamentarians. So say you were now a representative of a major company, and you would want to establish a strong business with privacy-friendly technology. But you currently did not see the reasonable incentives in the market for getting leverage into that market. What would you lobby the Commission for?
Yeah, to continue what they are doing. I must say, I'm quite happy then with the proposal, because I mean that's quite privacy-driven. It's driven by the fundamental right of data protection. We based most of what we had on also the jurisprudence of the German Constitutional Court in this respect. So I think I would be quite happy. Okay.
It's not to me to comment on that, but maybe on Jana, because Jana, you're going to put away your big corporation hat now, and you are advising for a European digital rights NGO. What would be your lobbying focus?
Just one sentence.
Well, 2 or 3 is okay.
2 or 3.
Or since the Commission had about 10.
Sorry.
Yeah, I think, as I said before, I would definitely advise to see the whole picture and not only the single right. I think it's important really to see the whole online picture and the online digital picture. Yeah.
Okay, with that, thanks to all my panelists here, Jana, Lorena, Elisabeth, and to the organizers for putting this up, this interesting conference. And I can see from your eyes that you're now looking forward to have a coffee break. Thank you very much.